Today, we will be discussing motions practice. Some of the learning outcomes today include defining what a motion is, exploring the motions practice, which includes preparing, serving, and responding to motions, and identifying specific motions commonly filed during the litigation process. So what is a motion? A motion is a written request or proposal to the court to obtain an asked-for order, ruling, or direction. Motions may ask the court for ruling in a matter, fees and costs, or an extension of time. There are a variety of motions, and it has become standard practice to file certain kinds of motions with the court based on the type of case. As a general matter, motions must be written, filed in court, and served on the opposing attorney. An exception to this rule is for motions made in court. Motions are also usually followed by a brief court hearing where the judge asks the parties questions about their motion and legal position. This is usually called an oral argument. Although motions look like pleadings in appearance and follow the same formalities, they are not pleadings. The person making a motion is called the movant. The documents included in a motion include a motion, memorandum in support of motion, affidavit in support of motion, notice of hearing, and certificate of service. Some courts, such as Hawaii state courts, allow parties to submit declarations instead of affidavits. Affidavits are often used in support of motions as evidence to support the party's case. An affidavit should be drafted in first person, describe the affiant, state whether the affidavit is made in support or in opposition of the motion, and state the facts supporting or opposing the motion. Affidavits should also be signed in the presence of a notary public. Now here is an example of what an affidavit looks like. You will note that there is a place for the notary to sign and stamp at the bottom of the affidavit. Whereas a declaration is signed by the declarant or the person making the declaration, and this document is not notarized. Courts still deem declarations valid despite it not being a notarized document. Similar to pleadings, motions must be served on all parties to the lawsuit, and a certificate of service is filed to reflect that the proper parties were served. Once served with a motion, the recipient of the motion has an opportunity to respond and file a memorandum in opposition. The memorandum in opposition may attach an affidavit or declaration to support the party's legal position. After a motion is filed, the court will schedule a hearing on the motion. At the hearing, the court will either rule or make a tentative ruling based on the documents and oral argument given by the parties. If the judge rules on the motion, an order is entered. Sometimes the court will issue sanctions to the non-prevailing party if the court believes the motion was frivolous. Some common pretrial motions brought by parties include a motion to amend the complaint or answer, a motion to dismiss, a motion for judgment on the pleadings, a motion to compel discovery, motion for protective order, a motion for summary judgment, and a motion for sanctions. These are just some of the common motions that can be filed, but in no way is this list exhaustive. We will not be covering all of these motions in detail, so all you need to know is that these are examples of pretrial motions and that these motions exist. Motions to dismiss, motions for summary judgment, and discovery motions are the most common types of motions and will be covered in more detail a little later. Motions brought at trial include motions in limine and motions for judgment as a matter of law. Finally, some post-trial motions that are commonly filed include motion for judgment notwithstanding the verdict, a motion for a new trial, motion to tax costs, and motions for relief from judgment or order. A motion to dismiss is a request that the court terminate the lawsuit immediately without a hearing on the merits of the plaintiff's claim. In a motion to dismiss, the movant is asking the court to dismiss the lawsuit on the basis that there is a failure of the pleading to state a claim upon which relief can be granted. A motion to dismiss is often made in lieu of an answer and is usually based on Hawaii Rules of Civil Procedure Rule 12b. A motion for summary judgment can be made by plaintiffs or defendants. In a motion for summary judgment, one party asks the court to order that judgment be entered as a matter of law without the necessity of trial because there are no real disputes regarding material facts. The standard in filing a motion for summary judgment is that there are no genuine issues of material fact and the moving party is entitled to judgment as a matter of law. Now let's talk about some discovery motions. A motion to compel discovery asks the court to order a party to comply with discovery requests and imposes some sort of penalty or sanction if the party refuses to do so. A motion for protective order requests that the court limit the other party's right of discovery. Now let's look at a sample motion for summary judgment that was filed in the Cvtanovich versus Doobie matter. Review the motion together with the memorandum in opposition and reply, all of which can be found in the Resources folder Motion subfolder. After you review the motion, please pause this video and answer the following questions. What was Nancy Doobie's argument in her motion for summary judgment? What was Jerry Cvtanovich's argument in the memorandum in opposition? If you were the judge, what questions would you ask the parties? How do you think the judge ruled? The next slide contains a stop sign to remind you to pause the video or refer back to this slide while you complete this exercise. At this point, you may pause the video while you review the Doobie motion for summary judgment. You may rewind this video so that you can refer to the previous slide. Welcome back. Now let's answer the questions. In the motion for summary judgment, Doobie argued that Cvtanovich's undue influence claim should be dismissed because she was not susceptible to undue influence. Cvtanovich argued that she was susceptible to undue influence based on expert witnesses' declaration or testimony. The court granted Doobie's motion for summary judgment because expert testimony cannot be used to support an ultimate fact, or, in other words, an element of a cause of action such as susceptibility. Therefore, Cvtanovich did not raise any issue of material fact sufficient to defeat Doobie's motion. Thank you for watching today's video, and please proceed to completing this week's activities.